Meshaq Berryman, you were convicted by the jury of 3 counts of attempted murder. Sadly, this is yet another case of very serious violence involving the use of firearms between street gangs within this city. Gang violence is a scourge of this city, as it is elsewhere. This was a planned attack. During the afternoon of the 24th of February of 2023, a funeral service was taking place, followed by a wake at St Mary's Church Hall on Hampstead Road in the city. The funeral was of a child who'd been murdered as a result of a gang feud. I make it clear the victim was a wholly innocent victim and wasn't a member of any gang. You, however, knew that members of the rival gang would be in attendance at the funeral, and you and others planned an attack upon it. A car was stolen and replaced. A gun and ammunition was obtained. The car was positioned in a quiet residential area away from prying eyes. And in the afternoon of the 24th of February, you made your way to the car. You left your top coat and your phone with another gang member to avoid being tracked or otherwise identified, and you then made your way to your target. You clearly were not alone. You were, on the evidence, the backseat passenger and the gunman. You left fibres from your clothing on the back seat and gunshot residue on your gloves. Whoever was driving the car drove to St Mary's Church, and you drove past to make sure everyone was there. They were. There was something in the order of 100 people outside the hall, together with those inside. You turned the car around and drove back to the hall. The car slowed down, and you then, as graphically shown on the CCTV, fired 4 times at the crowd from a distance of no more than half the width of the road. You then accelerated away. Of the 4 shots you fired, 3 struck home. Jack Cabert was shot to the left side. The bullet passed through his left arm before entering his chest, where it lodged. It fractured 2 of his ribs. There was damage to the lung tissue and associated muscle. There was bleeding into the chest, and an operation had to be performed to remove the bullet. Hassan Khan was shot to his right shin. The bullet lodged in his shin bone, which was fractured, and an operation was required to remove that bullet. Ashon Deguier was more fortunate, although still injured. He received a shot wound to his left foot, causing wounds to 2 of his toes. The scene at the funeral was one of utter terror. Everyone tried to run to safety inside the hall, causing some to be near trampled underfoot. Others tried to help the wounded. Some, fortunately, applied a tourniquet to Mr. Khan's leg to stem the bleeding. The effect upon the mother and loved ones of the child whose funeral it was can scarcely be imagined. You and your accomplice returned to where the car had been, recovered your telephone and coat, and were taken away from that area by another gang member. The car was subsequently moved and abandoned elsewhere. The gun, scientific evidence relating to the spent cartridges indicate that it was likely a re-barrelled 9mm pistol, has never been recovered. There was overwhelming evidence before the jury that you were a member of a street gang in Newtown and part of drill videos that threatened to shoot and kill rival gang members, and particularly those who you believed were connected to the funeral. In your own evidence, you accepted you were part of a gang, and you were photographed a few weeks later making hand gestures intended to show how rival gang members had indeed been shot. I make it clear in the case of Mr. Khan, one of the victims, he had nothing to do with gangs and was simply attending as a mourner. The effect upon Mr. Khan was significant. His injuries affect his walking and become painful. He was only 19. Unsurprisingly, he has flashbacks. The funeral was of his best friend. He's now reluctant to socialise and suffers significant psychological effects. The mother of two girls who were at the funeral has vividly described the effect upon her children of being near trampled at the scene and how they've suffered with nightmares and are frightened of going out or even hearing sudden bangs. When you were arrested, you were also found to be in possession of Class A drugs, and you pleaded guilty on the first day of your trial to 2 counts of possessing Class A drugs, a little over 100 grams of cocaine and a similar amount of heroin, and also cannabis, Class B, all with the intention to supply. That also related to your gang activities. Against that background, I now turn to the Sentencing Council guidelines. Each of the 3 counts of attempted murder involved the use of a firearm and are therefore of very high culpability. As to harm, it's submitted on your behalf by Mr. Pinnock that each case should be Category 3 harm. I agree with that submission in part. The injuries to Jack Gabea were not within the very serious injuries within Category 1, but his physical injuries were undoubtedly serious and therefore fall squarely within Category 2 harm. Mr. Khan and Mr. De Geer were more fortunate, but nevertheless suffered significant harm, and those 2 offences do fall within Category 3. The starting point, therefore, for Count 1 is one of 30 years imprisonment, and in relation to Counts 2 and 3, a starting point of 25 years. There are significant aggravating factors. As is clear, this attack involved significant planning, both to commit and to try and escape detection. It's right that the public know that this involved a long and very detailed police investigation, involving over 1,000 hours of viewing CCTV in order to identify and track you. It was painstakingly and accurately done, such that at your trial, challenge was only of a few moments of it, and the police are to be commended for the thoroughness of the investigation in this case. Further, the circumstances of the attack speaks for itself. This was an attack on those who were mourning the death of a child. Not only were you aware of that, it was chosen for the attack. As to the drugs, it's agreed that in relation to Class A drugs, their Category 3 significant role with a starting point of each of 4.5 years imprisonment and 1 year in relation to the cannabis. The aggravating factors are your previous drug convictions. I now turn to mitigation. I've read the letter you sent to me and the 3 references sent on your behalf. In relation to the letter, despite the overwhelming evidence, it's clear you continue to deny involvement and therefore have showed no remorse for your actions. You have previous convictions. I accept they're for supplying drugs and not for violence. However, as Mr. Pinnock has correctly submitted, there is mitigation in relation to your age and overall maturity. You were 20 years of age when you committed these offences. As I've described, by then you were deeply immersed in gang culture. I've read the moving letter from your grandmother, which describes a depressingly familiar situation of how you became drawn into gang culture when you were very young and have remained with it. I've seen and heard you give evidence. I have to assess your overall maturity. It's clear from what I have described that you had many problems as a child which were not of your making. You received no consistent education, and the influences that operated upon you were malign. As Mr. Pinnock has correctly observed, even by the time of these offences, you were still living in what he properly described as squalid circumstances. It's well established that young men, even of 20, have frequently not fully matured, and most adults only reach full maturity when they are about 25. Having considered all of the evidence and having seen you give evidence, I do consider that in your case you remain some way from full maturity. That reduces your culpability, and therefore that must be reflected in the sentence passed. I have to balance all of those factors. To begin with, in relation to count 1, there is, as I've said, a 30-year starting point. There are significant aggravating factors that I have identified. Apart from your age that I will come to, the only mitigation is that you have no previous convictions for violence, but that can only have a limited effect given the offences that you have actually committed. Before reduction for age, the shortest sentence on count 1, standing alone, that I could impose would be one of 24 years imprisonment. 34 years imprisonment. And in relation to counts 2 and 3, the sentences on each would have to be in the region of 27 years in relation to each. I then, however, have to have regard to totality. That means adding all those sentences together would lead to an obviously disproportionate sentence. I accept also that whilst these are separate offences, they were in fact committed within seconds of each other and were all part of the same incident. And I therefore have to look at that incident, consider each of the offences, but then determine what is the appropriate sentence that properly reflects the seriousness of what took place. In my judgment, the shortest total sentence to reflect the overall criminality in the case of a mature adult would have been one of 42 years imprisonment. For the reasons I have set out, I reduce that sentence in your case by 1/6, a significant reduction to reflect your age and maturity at the time you committed these offences. That means the total determinate term for these offences would be 35 years imprisonment. I must deal also with the drugs at this stage. In relation to the Class A drugs offence, the overall sentence for them would have been 5 years, reduced to 4, having regard to the factors I've just set out. You eventually pleaded guilty to those offences and therefore entitled to a reduction of 1/6, which would result in a sentence of 3 years and 4 months. And the sentence in relation to the cannabis will be 12 months. However, I again have to have regard to totality. It's a very long sentence that has to be imposed for the offences of attempted murder, and I would therefore significantly reduce the sentences in relation to your drug offending. Given all of your offending arises from gang membership, I would reflect the drugs offences by increasing the total sentence for the shootings by 1 year to reflect the totality of the criminality for the associated drugs offences, which would result in a total determinate term of 36 years imprisonment. I now have to consider whether you represent a danger to the public. Namely, is there a significant risk of you causing serious harm to the public by committing further specified offences. I have to consider first the nature of these offences. This was a determined attempt to murder a number of people. You in fact fired 4 shots, although only 3 struck targets. You fired from a very close range into a large crowd of people. It's remarkable that 1 or more were not killed. To make such an attack demonstrates that you had no regard at all for human life. The offences are undoubtedly so serious that a life sentence would be appropriate. I accept you have no previous convictions for violence, but your drug convictions also reflect your deep involvement in gang culture. Given your involvement in these offences, you clearly represent a very grave danger to the public. And given the gravity of the offences, no realistic estimate can be given of the time for which you will remain such a danger. I'm also satisfied that there is no available alternative sentence. In those circumstances, I'm satisfied that the only sentence that can be imposed on each of these counts is one of life imprisonment. That means what it says. You will remain in prison for life unless the parole board is satisfied that a time has come when you no longer represent any danger to the public. In that regard, I have to set a minimum term that you must serve before the parole board can consider your case. I'm required to set that minimum term as representing 2/3 of the notional determinate term which I would have imposed otherwise, which, as I've explained, would have been 36 years. So can you stand, please? The sentence on counts 1, 2 and 3 concurrently is one of life imprisonment with a minimum term of 24 years. You have been in custody for 680 days. That will count towards the term, and I'm required by law to state what the minimum term is now, today, taking into account the time already served. The minimum term from today is therefore 21 years and 150 days. There will be concurrent sentences of 3 years and 4 months for counts 5 and 6, the Class A drugs, and 12 months on count 7, the cannabis. There will be destruction and forfeiture of the drugs and paraphernalia recovered, and the victim impact surcharge will apply. You may take Mr. Berryman down.